Hello, and welcome to another edition of USPTO Hour. My name is Kim Kelleher, and I am the Deputy General Counsel for Enrollment and Discipline and the Director of the Office of Enrollment and Discipline. With me here today are my two colleagues, Grant Corboy and Tim Rooney. They are OED staff attorneys. Typically, when we speak, the office gives a talk about the two main functions of the office: enrollment of patent practitioners so that they may be able to practice before the office in patent matters, and investigations of allegations of misconduct by practitioners, sort of a yin and yang situation. Here today, though, we're going to talk about three of the programs that are run out of the office. And those are the Diversion program, Law School Clinic program, and Patent Pro Bono program. Before we get started, however, if you have any questions as we go through the slides, please email them to usptohour@uspto.gov. We will try to get to as many questions as we can today, but if we don't get to your question, don't worry. We will circle back with you as soon as possible. And with that, I'm going to turn to Grant and ask him some questions about our diversion program. So Grant, welcome.
Well,
Can you please explain a little bit about OED's diversion program?
thanks, Kim. The diversion program is very similar to the alternative discipline programs that have been implemented across many state bars over the past 20 years. So the OED diversion program is basically our alternative discipline program. It's an alternative to public discipline available in cases involving minor misconduct. What it is we typically divert the practitioner from conventional discipline to a treatment plan with the hopes that we are proactively addressing the condition or disability which may impair his or her ability to practice ethically. The idea being that preventing the minor misconduct from escalating into a major misconduct, all while protecting the public.
So why was the diversion program created?
There's a long felt need, Kim. Recently, there's been a bunch of studies about the problem with mental health within the legal profession. So there's been several studies that have disproportionately found that disproportionately high levels of impairment among attorneys for substance abuse, stress and burnout, and mental health issues. So let's get to the studies. In 2016, this is probably the most comprehensive study. It was done by the ABA and the Hazelton Betty Ford Foundation. They surveyed over 13,000 practicing attorneys. Subsequent to that, in 2022, there was a study titled Burnout and Engagement's Relationship to Drug Abuse in Lawyers and Law Professionals. And perhaps maybe more importantly and recently in 2026, the Washington State Bar Association formed a member well-being task force where they surveyed more than 900 practicing attorneys. And in that survey, and this is pretty much constant through all the surveys that I mentioned, through that survey, 10% of the practitioners surveyed or the attorneys surveyed had suicidal ideations over the past year. 20% expressed concerns about alcohol consumption. Other interesting numbers: 6 in 10 reported feeling burnout, 16% experienced persistent depression, and 57% reported anxiety symptoms. The final conclusion of the WSBA member well-being task force said there is widespread stress, burnout, and mental health concerns across the profession. And maybe even more concerning, at least in the 2022 study, they found that many of the rates of drug and alcohol abuse and depression were higher in younger attorneys below age 30. So it's important to address this now before it escalates into a bigger problem.
Those are some staggering numbers, Grant. And I have heard, through other state bars that they have things called lawyer assistance programs. Can you explain what a lawyer assistance program is, or a LAP?
Great. Yep. So a LAP program is operated by the state bars and provide confidential support to legal professionals. Usually those LAPs, and the reason they're formed and able to function is because they're sponsored and paid for by dues of the attorneys that support the bar. LAP programs have been established in 53 state bars, and I know, Kim, you're going to say 53 states. When do we get 53 states? It's actually 50 states, the District of Columbia, Washington, D.C., Puerto Rico, and the U.S. Virgin Islands. And you can gain access to assistance if you just go on to the American Bar Association website and type in LAP in the upper corner in the search bar, and you'll get a directory. And those directories are listed by state. So you can actually visit the website of those LAP programs or the contact and email address of somebody you can reach out to if you want to engage those LAP assistant programs.
Excellent. So when was OED's diversion program created?
We're still relatively new to the game, Kim. Our pilot program started in 2017. And then in 2022, we published an NPRM, and I know USPTO loves its acronyms. NPRM is Notice of Public Rulemaking. So anytime the government wants to do something, we put the public on notice, and we give a Federal Register notice where the public can come in and comment. And so some of those comments that we received were from the ABA and the AIPLA, and they thought formalizing the pilot program was in the best interest of practitioners. So we went ahead, and on August 14th, 2023, we established a final rule, sort of memorializing the OED's diversion program, and you can find that in 37 CFR 1130.
So, what areas of are there for potential participation in diversion?
Yep. So if you're considering, and this is what we found over the years that we've been doing this, is that there's really three categories. It's alcohol or drug addiction, so where the practitioner has a relationship with alcohol or drugs, physical, mental, or emotional health issues, or inadequate practice law office management skills.
And what is the current status of OED's diversion program? Can you run through some of the information cumulative over the years?
Sure, Kim. So, 7 practitioners have successfully completed diversion agreements. And I know you're thinking, wow, Grant, didn't you just say it's been 2017? It's been a while. Well, I like to think that we've got a very well-behaved bar. So I think that's part of it. I think the other side of it is that just the very nature of addiction, and I'm sorry, I'm coughing. I've just got a little frog in my throat.
It's that season.
It is that
Take your
season.
time.
So, there is an article written in 2017 by the New York Times called The Lawyer, the Addict. And it talked about this was a patent practitioner who unfortunately lost his life due to an overdose. And what his wife came out in the article and talked about was the fact that this is something that he really hid from everybody, right? It's like they kept making excuses and oh, maybe it was a bipolar issue, maybe it was an eating disorder, but he did a very good job of hiding it. And so a lot of times when we go out and ask questions, we don't know unless the practitioner that we're investigating comes forth with that information. So I think the numbers, will probably maybe a little higher, but it's just the nature of the hidden nature of these, mental health issues that aren't readily disclosed. And so what we've been doing to kind of bring it about a little bit better is in our initial uh, RFIs or requests for information, we include a flyer that has information about the program. That way, the person's aware of the program and is willing to hopefully disclose it to us so that we can consider them for diversion. It's important to know that diversion continues to be an option for those practitioners who struggle with substance abuse, mental health, and law practice management issues.
Yeah, and I think your point is well taken. The more we discuss it and talk about it and have presentations like today, the better informed we are moving forward with regard to diversion and the issues surrounding it. So, can you talk about some of the benefits of entering into diversion?
Yeah, I think this is a program that really helps proactively address the issue. So it does do efficient and effective protection of the public, which is the purpose of discipline, which is by addressing a minor misconduct, as said in the first slide, diversion is for minor misconduct.
Mhm.
Um, it gets it before it escalates. And so, also, and going back to the 2017 New York Times article about the hidden nature of it, diversion is confidential. It's not public. It's between the Office of Enrollment and Discipline, the practitioner, and typically a counselor or some sort of doctor or some sort of professional that is experienced in dealing with these mental health issues. So by not advertising it to the world, we're hoping that it more people are readily going to disclose it and and get the treatment and help that they need for for their physical or mental condition. And so it encourages the practitioner in seeking appropriate remedial assistance. Again, this is very important that we get to it early so that it doesn't escalate and become, a bigger problem where we end up, having to suspend or exclude somebody. Get to it early so that they continue to provide excellent and valuable service to their clients.
So, you mentioned minor misconduct as being one of the requirements in order to enter into diversion. Are there other requirements, and can you tell us a little bit more about what they would be?
Yep. So the good news, Tim, is we didn't just generate this out from whole cloth. As said, we came relatively late to the game, and the state bars were already doing this. So our rules are modeled after the ABA and a lot of what the states are doing for these alternative discipline programs. Also, not written in the rules, and this is kind of very important. There really has to be a nexus between the physical or mental health issue and the misconduct. Because remember, we're going to be treating the goal of the program, right, is to treat the mental or physical health issue. If that's not a result of the misconduct, then you're kind of missing the purpose of the program. So again, you're not going to find that in the rules, but there really does have to be a nexus between the two. The practitioner has not been disciplined by the USPTO or another jurisdiction within 3 years. This is sort of the exception swallows the rule because a lot of times we'll get a referral over from a state bar, and maybe somebody missed a filing date because they were depressed or something, and that gets referred over to us. Well, that would not stop us from implementing diversion on that case because it was referred over from a state bar for the same conduct for the same set of facts. So the conduct does not involve, and I want everybody here to think about the minor misconduct because what I'm going to be mentioning here are sort of major things, right? So misappropriation of funds. So if you're stealing, that's major. If you're stealing from your client, that's major. And so it would not be a candidate for diversion. If you're dishonest, deceitful, fraud, or do misrepresentation, that's another, case that's not a candidate for diversion. If the conduct has resulted in substantial prejudice to the client or other person, again, that's not a minor misconduct, so it's not something that would be a good candidate for diversion. If the conduct is a serious crime, the serious crime, I'm not going to get into it, but you can find it under 37 CFR 11.1. We've defined serious crime. But again, it's serious, it's not minor, so it's serious misconduct. And similar, a pattern of similar misconduct. So again, it goes to really scope and scale. If it's a pattern and continues on for a while, then it's again probably not minor misconduct and wouldn't be a good candidate for diversion unless the misconduct is minor and related to a chronic physical or mental health condition or disease. Then it would be, a potential candidate for diversion.
Are there other factors that are considered when thinking about entering into diversion?
Yep, and I'm going to sound like a broken record, but if again, so if you are being investigated and the conduct would deal with a major suspension, a year, 2 years, or an exclusion, it's not a candidate for diversion because the section should be around the public reprimand or no more than 30 days. Again, it's minor misconduct, minor prejudice right to the client are the candidates that are better suited for diversion. The other thing that's really important is whether the practitioner has cooperated in an investigation. Past performance from OED's perspective is the only thing that we have to rely on to see whether a candidate, right, or a person participating will comply with the terms of the diversion agreement. So if you've cooperated in the investigation, OED's position is that you're more likely to be able to cooperate and fulfill the terms of the treatment plan as well as the diversion agreement. Whether there are aggravating or mitigating factors exist, for instance, if you've been practicing for 20 years and unfortunately, maybe due to the death of a family member, you became depressed and missed a couple of filing dates, right? Well, that's a mitigating factor. You've got 20 years of great service, right? And so that's something we consider. Another thing is whether diversion was previously tried, right? We want to care about success. If diversion was tried before and it didn't result in a successful conclusion, you're back before us again. It doesn't seem as though that would be a good candidate for diversion because you've already tried and you weren't able to successfully fulfill the obligations of it.
So, Grant, can you take us through the nuts and bolts of the diversion program and its process?
Yep. So this is great because recently, Kim, we've been seeing a lot of initial responses to our RFIs saying, "Oh, I love diversion." And really, we need to understand where it is in the process. So when we get some information about a practitioner, we evaluate it and we may open an investigation based on that information. The investigation, right? That's when we reach out to maybe the grievant, we reach out to the practitioner, maybe a couple witnesses. We look at the filings that that person's done. We get all that information together, we assemble it, and then it's ready for a disposition. Based on that information, we can go sort of a closed no action. We can issue a warning, which is a non-public discipline. We can pursue formal discipline. We can also enter into a settlement agreement, or we can enter into a diversion agreement. And it's important that you understand it's after the disposition. So we have all the information. I keep coming back to it. I know I sound like a broken record, but after we have all the information, we can understand if it's a minor misconduct. We get all the background on the ethics violations that have been violated, as well as the reasons for those. So it really makes sense to handle it at the disposition, not early on in the investigation where we're still collecting all the information from the practitioner and from all those other individuals.
That makes sense. So, what are some of the general terms that go into a diversion agreement?
Okay, so this is important that OED does not have a staff of health professionals or doctors. And so typically what happens, and we can talk about the state lab programs, but the practitioner that's being investigated will go out and engage a health professional, and the practitioner bears the cost of that health professional. And so then that health professional is going to make some recommendations. Okay, so the person needs to be treated for depression. They need to go to counseling sessions. Those treatment plans become part of our diversion agreements because OED is, we are not medical professionals, so we don't know really how best to treat those underlying issues. And so that, we're going to defer to those professionals. And that again will become part of the diversion agreement. It's important to note that if during the agreement or the health treatment plan, there is a breach, it will cause termination of the agreement, and OED may pursue discipline. I've had one recently that I put a term in there that said, hey, failure to comply with the terms of the agreement will implicate maybe 804I, which is the fitness, the conduct and fitness of the practitioner to practice before the office. And it kind of makes sense to me because if you're going through a treatment plan and you don't finish the terms of the treatment plan, then you're sort of saying that you don't, have the condition or the fitness to practice before the office. But the good news is, Kim, is whatever it is, sometimes it'll say, okay, immediately go to public reprimand. The good news is that in the diversion agreement, it sets forth what happens when you materially breach the agreement. So there's no surprises for somebody who's taking the agreement. Both parties, right, OED and the practitioner, agree to those terms and agree to what happens when there's a breach of that agreement. And I'm happy to say, Kim, to date of those 7, everybody has successfully completed the diversion plans, and we haven't had to worry about breach of the agreement.
Awesome. So, what are some additional potential conditions that we can add into the agreement for diversion?
So a lot of it has to do with substance abuse treatment, right? If you have a relationship with alcohol, maybe it's attend AA meetings. It's whatever the medical professional sees. Maybe, for instance, it's a car interlock. Right? So in other words, you want to make sure that the agreement will have a car interlock where you've got to breathe into the car to make it start. Mental health treatment, ongoing counseling, treatment for a medical professional, training, education, and mentoring. Maybe you need to bone up a little bit on your ethics, so it'll be a CLE ethics course. Implementation of new practice tools. Maybe you're a small, struggling solo practitioner and are using an Excel spreadsheet, and now you need new docket management tools. So it could be helping implement those new tools. Restitution. I know if you go back before, you say, well, I thought it was if you are stealing from your client, that's not a case. Well, restitution could be, it means to restore or make whole. So maybe you missed a deadline, maybe you had to pay an extension of time fee. We want that extension, right? Maybe that restitution is you paying it instead of the client paying it. And practice monitor, state bars often allow practice monitors or offer practice monitors so you can coordinate with a state bar who can be somebody to bounce ideas off of to really help you with your practice.
So, our practitioners, our patent practitioners, in part consists of patent agents, and patent agents are not attorneys and they are not lawyers, but they're authorized to practice before us in patent matters. Can they participate in our diversion program?
Yep, well, you're right, Kim. So the practitioners that are attorneys, they often work through the state LAPs, right? The lawyer's assistance programs. But that doesn't mean if you're a patent agent, you're not able to get access to diversion. I think the first thing that we'll typically do is we'll say, hey, reach out to your state bar and see if they'll allow you. Some state bars do allow patent agents to participate in their labs. If they don't, then it's going to be incumbent upon the patent agent to reach out, get that professional that we talked about earlier, and get the assistance that way.
So we have a slide here on more information that if people are curious about diversion, where they can go. Can you walk us through a couple of the sites and definitely the telephone number?
Yep. So, Kim, if you actually go to the OED's website, we have information or resources for current practitioners. If you click on that, it's got great information about the diversion program. I'll particularly pay attention to the diversion guidance document. That's what we use here to see if whether a candidate is a good candidate for diversion. So it goes through sort of the things that we look at and the things that we consider um, in making that determination. And also, there is the OED helpline. If you call 571-272-4097, we have somebody there 5 days a week. You're free to talk to them and ask questions about the diversion program through there.
Excellent, Grant. Thank you very much for the information. We're going to turn back to you at the end, towards the end of the hour. We'll give you a little bit of a break.
Thank you. Right here.
Well earned. And we'll turn to Tim to talk a little bit about the Law School Clinic Certification Program. Hi, Tim.
Hi, thank you so much for allowing me to talk about one of my favorite programs here at the U.S. Patent and Trademark Office, the Law School Clinic Certification Program.
So, thank you for being here. And can you please walk us through this wonderful map that you have up on the screen?
Yeah, so this map is showing the different programs that we have in their locations and what type of practice they participate in, and it really is a great program. It's something where everyone wins, and so I'll explain that in a little more detail. In that the public wins with this program because this is a resource. It's yet another resource for pro bono legal services, and those can be scarce, and demand can be very high. And as you can see from the map, we have schools throughout the country, and we have a lot of schools, 75, and we'll go through those numbers on the next slide. But before we do that, I just want to say that number, it really does provide kind of a variety of different types of schools, different programs that provide different services. And so the public wins because pro bono resources are very important in IP, intellectual property, patents and trademarks. Specifically, it can be somewhat costly to engage an attorney, and so I think having pro bono programs out there really is valuable. The other party that wins is the students. The students benefit greatly from being able to have a real world experience before they leave law school. So normally, you're a law student, you're learning black letter law, you're studying cases, you're studying statutes. Well, this type of experiential learning allows you to really practice and meet with clients and talk with clients and organize your time. You learn a lot of time management skills, and I'll get into the nuts and bolts of it a little bit later, but they allows these students to interact with trademark examining attorneys and patent examiners. It allows them to, learn how to write an email that gives, good news or bad news. Sometimes there's things that a client doesn't want to hear, but might need to hear. And so all of these things happen in a real world setting, and it really helps out the students. The schools also, and you can see all the schools on our map here, they win. Participating schools really get this as a tool to recruit students to come work with them. And as we'll talk about, the students get that limited license, and so this is something that they can use to attract students to their schools. And finally, I'll talk about the employers. The employers who are going to recruit law students out of a school that participates in this program. They get more practice ready lawyers, people that have done that real world experience and can hit the ground running. So it's really an excellent program. I'm happy to speak about it today.
So, can you give us a little bit of history about the law school program?
Certainly, it began in 2008 as a pilot program with 6 schools. 5 of those schools are still in the program. They're one of the 75. And the University of Maine is one of the 6 that is no longer with us. But I think what that is a good illustration of is that the schools participate to the level that they can and want to. And if that sometimes means that they cease participation in the program, whether because the clinic is closed, whether because they lost a supervisor, or for any other reason that happens to exist at the school. We do have expansion windows that have opened in the past, and we have them listed down here, and that's how we got to 75 schools. We don't have that open constantly. We want to make sure that we have the internal resources to serve the program. Students get that limited recognition license to practice, and so we have to take in applications from students. We have to evaluate supervisors and things like that. So we want to make sure that we can do that effectively. And so right now we're in a period where we're not accepting applications, but we're looking into opening that up again. And quickly to break down the numbers, we'll talk about the different disciplines, but we have 38 schools in patents and trademarks. They do both. 34 of the schools do only trademarks, and 3 do patent only. That's illustrative of, the schools participate in the genre, in the type of law that they want to. They determine what they do.
So, what kind of services does the law school clinic program provide?
Yeah, so the nuts and bolts of the system are of the program are, and we've been through a couple of slides. I'm just kind of giving you the elevator pitch now, but the program allows law students to who are enrolled in a participating law school clinic to practice before the USPTO in patent or trademark matters. So depending on the student qualifications, the clinic curriculum, they can do patents or trademarks or both. And all of that practice is provided under the strict supervision of a certified faculty clinic supervisor. We'll talk about what that means a little bit more later. And all of these services are provided pro bono, and that means the legal fees would not attach. Those are pro bono, so no fees there. But I should mention that the agency fees, so the fees that are paid for filing an examination, maybe an issue fee, a registration fee, things like that, those are paid by the clients, but the legal fees are provided pro bono by the clinics.
So what can the clinics do?
They can do they can do things other than patent or trademarks, but depending on what side of the program they enter into, and they can enter into both. They can do patent prosecution or trademark prosecution. It means filing applications. It means filing responses, interacting with examiners, doing appeals, things like that. So really anything that involves prosecution of a patent or a trademark matter to obtain a register a trademark or obtain an issued patent. Now the law schools have to apply separately. If there's a school that wants to do both, they have to submit 2 different applications. And we evaluate those based on things like the IP curricula, so that they're intellectual properties classes that students have to take. So that would give them a background, that's essential for practicing in this manner. What type of IP faculty do they have? So who's doing the teaching? What their client outreach plan is. We want them to basically reach the potential clients in their community, whatever geographic area they choose to serve. And then very importantly, the proposed supervisors. Who is proposed to lead the clinic and be responsible for all of the work that the students do?
So you just mentioned those faculty supervisors. Can you walk us through what the requirements are to become one?
Yes. So yeah, every clinic that participates in the program must have at least one faculty clinic supervisor, and that supervisor can supervise in patents and trademarks if they qualify for both, or you can have one that does just patents and one that has just trademarks. So the way we evaluate the proposed supervisors is that they must demonstrate that they have at least 3 years of experience prosecuting patents or trademarks before the USPTO within the past 5 years. And really what to go in deeper to that is we want folks with recent practice experience. If maybe you were in private practice and you were a patent attorney for years, and then you went into academia and you've been teaching for the past 10 years, that person would not be approved as a supervisor. We want folks that know the current law and the current procedure, and they've interacted with the USPTO IT systems, because the USPTO does a great job of updating their systems, and we have fraud protection systems and things that are in place that you need to know when you're filing things with the USPTO. And so we want folks with that recent experience, and they can pass that on to the students and really serve the clients right away without having to teach themselves how to use those systems. Also, some specific things for patent supervisors: they have to be a registered practitioner, so a registered patent attorney or a registered patent agent. And then trademark supervisors must be licensed in and have a valid law license in a state or territory of the US. And that's commensurate with what generally you need to be able to practice before the office in trademarks.
So the law school clinics operate out of the law schools. How do they provide services to the clients?
Yeah, that's a great question, and this is an opportunity to express one of the other great parts of this program is that the law schools themselves determine their level of service and their level of who they serve and what things that they can provide for clients. So we're not going to the schools and saying you have to file this many applications in a given semester, or you have to admit this many students. We want them to participate at the level that works best for them, because that's how they're going to provide the best service for the clients and the students, right? Those are the two important parties here. And so that means how many clients to engage. We're not going to set a level for that. It can be as high or as low as they want, as much as they can handle, properly. It's what type of clients or what type of, inventions or marks they want to take on. And we do get inquiries at times, I wasn't taken by this clinic. They may have even had a spot open, but they didn't take me, and that can be because the clinic decided that it's best for their students that they do a certain type of work over another type of work, or a certain invention over another invention. They're making that determination. They're the professionals that are providing the legal services. And you notice the third big bullet point down there on this slide is the USPTO does not provide the legal services through this program. And so again, we get questions that say, hey, how do I get help? And so what we do is we refer those potential clients to the clinics, and the clinics are the ones that make the determination on who to take on and what's best for them. You'll notice what services to provide is a bullet point there, and then the last large bullet point is they provide things other than patent and trademarks, or they can. Some clinics are just patents or just trademarks. Some are both. Some do other intellectual property services like copyright or trade secrets. But some are entrepreneurship clinics or small business development clinics or community development clinics that serve businesses or nonprofits. They'll do things like corporate formation. They'll do contract work, non-disclosure agreements. Those are not under our purview, but it's a great example of how we have this variety of schools that can provide a variety of services to their clients. And trademarks or patents might just be a small piece of that. So there's a great story. We had a student who graduated and went into corporate law, not necessarily trademark law, but she was in a trademark clinic. And she was sitting with a lot of the more senior attorneys, and there was an issue that popped up for one of their clients about a trademark, and she knew how to get onto the USPTO website and do a very quick search because she had been in the trademark clinic, and really impressed everyone in the room. And it's just didn't go into be a trademark attorney, but just gained valuable experience that she could use later on. So it's really a kind of more holistic opportunity for some of these students. And I'll mention before we move off this slide that the schools determine what geographic footprint they serve. Some schools will serve just a small region within near their city. Some will serve the entire state that they're in. Some will serve multiple states or a region, and then others will serve the entire United States. And again, that's a variety. We have a variety of schools. We have plenty of schools that do serve the entire United States, and that's a great thing because again, you get the schools determining their level of participation.
That's a great story. I love that story. All right, let's move on to some numbers and see what the clinics have been able to provide to the public.
Yeah, so here you see the number of applications, trademark applications, over 8,400 filed since the program started, and over 2,000 patent applications. And both patent and trademark applications can be complex and involve different legal issues and different analysis. And so that's really a great amount of legal work that has been provided pro bono through these programs.
And then patents issued and trademarks registered by the clinics?
Yeah, and these are the success stories, getting rights for their clients. Over 3,800 trademarks registered and over 420 patents issued. And I'll use this as an opportunity. I mean, these are the intellectual property rights of these applicants and inventors, and it's their rights. And this is using these legal services to obtain that protection so they can leverage those rights for their businesses or their own use. So I think it's really great here that all these rights have been granted and have been assisted by these programs.
And then the back and forthing with the office.
Yeah,
correspondence.
Exactly. You might be familiar in the audience with the fact that there can be a back and forth. There can be different things that you need to address during the course of prosecuting a patent application or a trademark application, and that involves discussing things and communicating with the office. And so that, these can often be involve very complicated legal issues. And so it's great to have these clinics on your side assisting with that. You can see these aren't cumulative statistics, but often in a given year there'll be 600 to 700, almost 800, and then in 2023 over 900 responses filed, and then in patents between 200 and 300 responses filed. And again, just a ton of legal analysis and legal work that's being done by the clinics.
And then the number of clients that have been served.
This is a great graph. I mean, it's something that allows me to talk about client representations, right? So it's not necessarily that an application has been filed. It's not that you've got an issued patent or a registered trademark, but it's a client representation, which may include telling the client this isn't the best idea. There's a blocking piece of prior art we found through a search. We found another mark that conflicts. You may need to put your resources, your time, your effort into a different direction. And this is in contrast to maybe some unscrupulous companies out there who just take everybody in and say yes to everything and take your money and file an application that may not ultimately be successful, and it may have been easily identified at the outset, because these folks are doing the legal analysis and they're consulting and even as I said at the outset, giving bad news to the client. The client may not want to hear it, but that's what perhaps is going to save them in the long run. So this is a great number. We've got almost 20,000 representations in the program.
All right, Tim, where can we go for more information about the program?
Well, the best place to go is that website, that top bullet point. Often we will get emails and we will get phone calls to the email address and the phone number, which is fine. But 90% of the questions we answer, we direct people to the website, because that's where you can find all of the participating and active programs. You'll see the map has some schools on it, and sometimes schools will go inactive. We'll take their contact information off the grid, but we'll leave them on the map because they're still in the program. They're just not active. So they have all the active programs. It has the active programs contact information. It has the discipline where they practice, whether it's patents or trademarks or both. And it has their geographic footprint. So it has the area that they serve. And so again, most of the information, most of the questions, we get questions about, can you help me? Can I get into the program? And we direct folks to that website, because that is how they can contact the different programs, and they're the ones who are going to say, yes, I can, or no, I can't help you.
Perfect. Thank you, Tim. We'll see you at the end of the hour.
Thank you.
We're going to turn back to Grant now. Grant, are you with us?
I'm back after about inhaling 20 lozenges, so I'm hopefully going to be fine now. So should be able to power through it.
Poor Grant. All right. Well, we're coming down the home stretch. We're going to talk about the Patent Pro Bono program. So can you explain for our attendees what the Patent Pro Bono program is?
Yep. Thanks, Kim. This program assists financially under-resourced independent inventors and small businesses, helping them prepare, file, and prosecute their patent applications. So this isn't in a program if somebody's infringing on your invention to send a cease and desist letter or file an ex parte appeal. It's just to prepare, file, and prosecute your patent application. And the reason we do it is quite easy. It's because the statute tells us to. So if you look on Section 32 of the Leahy-Smith American Invents Act, which was passed in 2011, it says the USPTO director shall work with and support intellectual property law associations across the country in the establishment of patent pro bono programs to assist financially under-resourced independent inventors and small businesses. And the reason I stopped, Kim, on establishment is because the USPTO is really a cheerleader. We encourage the formation of these programs throughout the United States. As you know, we examine the applications, so we can also refer cases to ourselves and then examine them. So these referrals are handled by 19 regional programs. And so they're the ones that work to match financially under-resourced independent vendors and small businesses to help prosecute their applications.
Makes sense. So what are some of the benefits of the Patent Pro Bono program?
I think the best benefit, Kim, is, and this is done through, we've been doing this now since 2015, is that when we interview the people that have participated in the program, they constantly say, but for this program, I would not have filed this application. And so it's unearthing, it's uncovering things that otherwise wouldn't have been filed. And so it increases patent applications filings as a result. It also improves patent quality. You can imagine it's difficult to write claims, to write specifications, to do the drawings. Having a professional whose job it is day in and day out to do this really improves the patent quality of what's being submitted to the office. The other thing too is we do have a pro se assistance center. So pro se is a funny word for doing it on your own. And so if somebody calls a pro se assistance center, well, the pro se assistance center might say, hey, have you considered the patent pro bono program? And so they'll refer the case over to one of our regional programs for them, hopefully to get matched with a practitioner to prepare and file their application. The impact for inventors is also big. It's the opportunity to work with an experienced patent practitioner. Again, filing an application is daunting. So having a practitioner sort of take that load off and have the practitioner focus on what he's good at or she's good at, which is filing the application, and having the inventor focus on his business, on the invention. It is a great, delegation of responsibility to parties. Over $54 million in donated direct legal assistance have been provided to inventors and small businesses from 2015 through 2025. And I know, Kim, you're saying, Grant, how'd you come up with that 45 million? It seems like a pretty specific number. So we do collect metrics. We've been collecting metrics since 2015. And one of the metrics that we collect are hours. And so the AIPLA has done a great job. Back in 2017, the AIPLA came back with sort of a rate for patent practitioners. And so we take that rate, we extrapolate it out to prior years and extra years, and take those hours that are submitted. And so you can see that that's a lot of free legal services that are being provided directly to help, small businesses and individual entrepreneurs.
That's great. It's a great number. And this is a great map. Can you explain whether or not we have current nationwide coverage?
Okay, so the answer to that is almost. So we have 49 states. We recently, unfortunately, lost Florida. But the good news is, Kim, is that we are working with an organization in Florida, and I hope in the next 3 to 6 months that program will come online. But what we do through these programs is we have some programs that cover individual states because there's only 19 right now, as I mentioned before. And so some cover individual states, some cover multiple states. And through that, we get this sort of mesh or nationwide coverage. And again, we'll have that Florida hopefully back up soon in the next 3 to 6 months.
So you said the term regional patent pro bono program. What are they?
Yep. So they're independently operated. Most of them are nonprofit organizations. They're volunteer lawyers for the arts type organizations that were providing assistance in the copyright and trademark space to artists predominantly, but they've been gracious enough to expand their portfolio to include patent practitioners and making matches in the patent space. We also have a large number of universities, such as Penn State, that support the program. And we do have one bar association, which is the State Bar of Michigan. So it is important to understand, because we get this call all the time from our mailbox or inquiry from our mailbox. Tell them to do this. The USPTO provides general guidelines, but these programs operate independent of any influence from the USPTO. They set their own policies and procedures. And so what you'll see a little bit later, and we'll talk about, is that means that some might have different financial screening requirements than other programs because they're basing it on the needs of their community, their local community, and not based on any dictate from the USPTO. Their main focus is the regional programs is screening and matching pro bono applicants, right? That's their bread and butter. That's what they do. And so the regional programs ensure that the applicants meet certain requirements. And the three that they're predominantly checking for is income, right? That they are of need, that they are limited means, so that they need the assistance because they couldn't afford a patent practitioner on their own. They have knowledge of the patent system. And what we do, and we'll talk a little bit more later, is it's important in the interaction between the attorney or the practitioner and the inventor that the inventor has some idea of the patent system and how to interact with it, and that they actually have an invention, not just an idea.
So let's pretend I'm an independent inventor. And can you explain to me a little bit more about those criteria that you were just describing?
Yep, the most crucial is the household income. It varies per program, typically up to 400% the federal poverty guidelines. So what that means, if I'm a single person household, that for a 400% federal poverty guidelines, that would be $63,840 and family household income, and I could still qualify for assistance. Now that number may change based on the number of dependents. But again, Kim, that's also regional program dependent. For instance, the State Bar of Michigan, the state bar sets what limited means are, and for them it's 200%. So that's going to be a lower threshold. So the key is for individuals seeking assistance to contact their local regional program to see what that financial criteria is. Applicants must also demonstrate knowledge of the patent system. We've got a nice course online that gives sort of patent 101 in a super nutshell, right? It's sort of a soup to nuts, how to, education about the patent system. What is a patent? What's a 101 rejection? What's a 102 rejection? What's a 103 rejection? And so there's a course, and what that does is you have to complete the course and present that certificate to the regional programs. And so what that is doing is certifying that you have some basic understanding of the patent system. And so when that person or individual gets matched with the attorney, they're able to better interact with that patent practitioner, and they understand, oh, I got a rejection. It's not the end of the world, right? There's this back and forth that goes on between the office. They're aware of it because they've been trained and took the course on it. Again, obviously, applicants must have an invention more than an idea. And this is important from a screening perspective because you don't want to waste the attorney's time. So the attorney will actually go and screen to make sure they have an invention, that they're able to make and describe and use the invention so that it's a full, flushed idea that comes out and is ready for patenting. Applicants, and this is important to know, that applicants are responsible for all USPTO fees. We don't want you looking, when the fees come due, looking at your practitioner and saying, hey, it's time for you to pay the fees. No, that comes from the applicant, and it's important because they have some skin in the game. But the good news is, Kim, is that we've got a reduction. Everybody who qualifies for the program should qualify under a micro entity, so they'll get 80% reduction in fees. And it's also important to note that the regional programs themselves may charge a $25 to $150 fee. Like I know, for instance, California Lawyers for the Arts charges $150. Well, that's a lot of money, and it is. But they spend a lot of time going around and doing the matching, recruiting volunteers, screening your application. And by the way, like California, for instance, they don't collect that $150 fee unless you're matched with a patent practitioner. So again, just be aware of that. This isn't a scam that's going on. There are people that are there that are doing the screening, and unfortunately, that takes time and effort and costs money.
So I'm a patent practitioner, and this all sounds very awesome. How do I volunteer?
Well, we've got 1,500 practitioners that have signed on to volunteers, right? Which is a great number, and that number seems very large, and it is. But understand that at any one point in time, maybe only 10 to 15% of those practitioners are available, right? They've got their jobs, maybe they've got a litigation, they've got another patent that they're prosecuting. And so we really need to juice that number up and get as many volunteers as possible because we understand that they're busy and not available at any one point in time. And Kim, maybe you can start getting on and registering more practitioners because you have to be registered in order to practice before the office. So as part of our enrollment and discipline function, we do register people, and we need registered practitioners to provide that service. And those registered practitioners are a great help because they improve the patent quality. Again, instead of a applicant filing an application on their own, they're now represented and using their skill and expertise preparing that application and filing it with the office. Also, and Tim mentioned this, and this is great, the professional advice will help the inventor better make this informed decisions because sometimes, Kim, the answer is, well, you're not ready to file yet, right? Sometimes you got to go back to the drawing board, and that really saves the inventor money, right? Instead of spending money on fees that they're not ready to file on, you have that consultation with the practitioner who can help the person make a better informed decision. Maybe, it's a look and feel, so you need design instead of the functionality, right? And so you get that dialogue, you get that back and forth with the practitioner. The practitioner benefits because, again, I'll say this is sort of like we'll do the pebble in the shoe, the thing that the person cares about themselves, the practitioner cares about themselves. A lot of states now are offering for the pro bono service CLE credits. Like I know that in Wisconsin they do that. I know in Colorado they now do that. So if you volunteer for the patent pro bono program, those hours can be used for continuing learning education credits, which is great. But the most important thing and the reason why people should be doing this is it really helps the inventor. It helps them, maybe become a job creator, but I'll tell you, my experience in working with the program is the inventors are truly appreciative of the service that these practitioners are providing. They understand, they typically they go out on the web and they say, oh my gosh, these people want $15,000 and they're going to give that to me for free. And when they learn that they get it for free, they're just so appreciative and thankful. And it does make you really feel good when you go and volunteer your time.
So you have brought us full circle, Grant. How do I get more information about the Patent Pro Bono program?
Yep. So we have a page that's under the OED webpage. And if you just hit that link, you come to our page and you get a map of the United States. And at that point, if you're a practitioner, click on one of those states, and every single state has a link where you can volunteer or sign up to your local regional program. If you have any questions about the program, you can email us at probono@uspto.gov. And that number that we mentioned before is the same number that's good. You can air your patent pro bono questions in that over the phone as well. There are two other programs, Kim, before we conclude out, that's sort of beyond the patent pro bono program. There's the TTAB, which is the Trademark Trial and Appeal Board program at that link. And then there is the PTAB, or Patent Trial and Appeal Board. They have a program that if you're not happy with the rejection that your examiner gave, you can appeal it. It's called an ex parte appeal. And I know they have a bunch of practitioners that are ready, willing, and able to assist inventors appeal their cases before the board.
Thanks, Grant. That was great information. I think we have time for maybe one or two questions, and then we'll wrap up this week's USPTO Hour. Tim, are you online? We'll give Grant another break.
Thank you.
I'm here.
So first question for you. If I am a patent and/or trademark practitioner and I want to get involved in the law school program as a volunteer, how do I do that?
So it's different from what Grant was talking about with the patent pro bono program, is that we don't solicit volunteers kind of from the pool of registered patent practitioners and trademark practitioners to be able to work in the program as an attorney to supervise students and help clients. You have to be involved. You have to be associated with one of the schools. So a lot of these are full-time professors that work at the schools or adjunct professors. But in some cases, there are other attorneys that work in the program that assist. Maybe they're certified or they just work under the certified practitioner, but you have to be associated with the school. So the best way to get involved would be to contact the schools. Typically, they already have the folks that they need when they're running the program, but it's always good to look out. You can look for postings for adjunct professors to assist with things like that, especially if you've already been involved in clinical education at the legal level. That's a great community, and you can kind of work within that community to use your time and work with one of the programs. But we don't take, or those programs typically don't take folks that just cold call and say, can I help with the program?
Got it. Grant, I think you're going to actually bring us home. We are 1 minute to conclusion, but let's try and get in a question about diversion. The question is, I am not currently under investigation, always a good thing. Can I still get access to substance abuse or mental health professionals through OED's diversion program?
Okay, so could you repeat that one more time, Kim?
So the question is, I am not currently under investigation.
Okay. So,
Good thing.
yep, good. Okay, so I think I get it. So if you're not currently under investigation, the diversion program is for somebody that is currently under investigation. It is not a lawyer assistance program that we talked about that are at the state bars. So what happens during the course of an investigation, when it comes up that there's some physical or mental or emotional health issue that's discovered during the investigation, and then diversion is an approach where you're diverting the person from conventional, right, from conventional discipline to, to seek treatment and a diversion agreement. If you're not under an investigation, there's nothing to divert, right? There's nothing to divert from a disciplinary perspective. But what I would encourage people to do is reach out to the local state bar LAP program because that's what they're there for. They're there to provide assistance, to get in front of it, to get the help that you need, and not wait for sort of the wheels to fall off the train and then get assistance when you're under investigation.
Great. Thank you, Grant. Thank you, Tim. I think that concludes this week's USPTO Hour. We thank you for attending, and we will see you next week.